Thank you, and it's my honor to be here. So I will present some practical view, of course, for the Polish native speakers and viewers. This case is very well known, but I would like to speak about problems and some obstacles concerning the start the investigation against the state bodies because of the crime that probably were committed. Grzegorz Ocieczek told about the normative point of view and the crime that could be made. I will speak about some practical problems with solving and starting investigation. So first of all, we need to start from the very beginning, and so from the concept of militant democracy. So the official concept of our state concerning the way of making power after the 13th of December 2023. In September 2024, the Prime Minister make the appointment and the whole conference with the representatives of the legal circles, judges, prosecutors, attorneys, academics as well, who supported the government in the way of decision. And Mr. Prime Minister thought something which is very important, but it was very shocked for many people in Poland. He thought, I will read you because this is the official website of the Prime Minister Bureau. If we went to restored constitutional order, the foundations of liberal democracy, we encounter a situation every day in which we have tools that do not allow us to repair reality. I am talking about legal tools prepared by our predecessors, whose intention was to destroy this order, not to strengthen or build it. Today, we need to act in terms of militant democracy. We will probably make mistakes or take actions that, according to some legal authorities, will be incompatible or not entirely compatible with the law. But nothing exempts us from acting every day. I do not think that the way out of this situation is to formulate legal proposals when the stage is still populated by political actors from whom the provisions, even those of the highest rank, are of no importance. Actors from whom political will is defined to be more important than the legal order or constitutional provisions. So it means, according to the Prime Minister, so official of our country, because the political situation is complicated, because the president of the republic was not elected from the same political circle, it means that the government should find the solution how to do it. And because we have let's say, as Mr. Prime Minister said, the constitutional crisis, and we need to restore the constitutional order, it means that we can make actions against the law. So the concept of militant democracy, according to the official of the representative of Poland, means that the Article 7 of our Constitution, so the principle of legalism, is not valid right now. So the political aim, the political goal is more important than provisions of legal acts. when we are talking about the militant democracy, of course, we can discuss about the history, about Karl Levenstein, about academic and former judge of the European Court of Human Rights, András Sajo from Hungary, who promoted the concept of militant democracy. But let me focus on the last book, which was published just before the elections in 2023. Transitional 2.0, Re-establishing Constitutional Democracy in EU Member States. One of the editors is Mr. Adam Bodnar, former and the first Minister of Justice and the General Prosecutor of new government of Donald Tusk. We have very many important academics, very famous academics, who published some articles. For example, Mr. Mirosław Wyrzykowski, former judge of the Constitutional Tribunal, he wrote an article with the title "The Constitutional Trap." And the thesis, the most important thing in this article is that because we are in a very specific situation, we should create a new doctrine in the constitutional law because we need to legalize some actions which are not against the constitution. Adam Bodnar, look at this article. Of course, the subject is quite neutral, let's say. Poland after elections 2023, transition to in the judiciary. Mr. Bodnar, he was just academic and senator. He said that, okay, we need to make all changes in the judiciary in Poland because of the political situation, and we cannot use the statutory law. We cannot use the act because the president should probably block all actions, use the veto in the proceeding. But in fact, we should find the solution in the EU law or international law. But look at very, very specific sentence in this article. This is in the conclusions. He said, transitional justice mechanism will also be important. Transitional justice instruments will also be important. It means that we are living in the very specific moment, a moment of transitional justice. What does it mean, transitional justice? Of course, we have transitional justice. It means that we use some other values, we use some other principles during this period, right? So normally, when we have the regular system, all actions are making on base of law and within the law. The legal, the principle of legalism, right? But now we are in the transitional justice. So that means that state authorities can make all actions because of the very specific moment and many specific goals. And in fact, from the very beginning of when the new government started, the ministers, the members of the new government, make actions which are openly against the legal system. 16th of December, so 3 days after the new government set up, we had the take over the media. It was the first time from the 1981 when the system in the public media was closed. We have January 2024, unlawful removal of National Prosecutor Dariusz Barski from his official duties. Then, suspicion of payments from the state budget to the Constitutional Tribunal and the National Council of the Judiciary. So, the government wanted to switch off all all bodies who can control or block the actions of the government. Removal of judges from adjudicating. So, of course, after prosecutor, we need to have the courts. Suspensions by the Minister of Finance of payments to the largest opposition party, this by the decision of the State Electoral Commission. That was during the election, presidential election. Non-recognition by the government of the rulings of the Supreme Court at the Constitutional Tribunal. So it means that all judgments which were made by the Constitutional Tribunal and the Supreme Court who are not going or not support the political point of view of the government were just neglected. Paralysis of the Constitutional Tribunal by failing to elect judges. Now we have a new situation. Of course, from more than 2 years, the government did not, and the majority did not elect the new judges to the Constitutional Tribunal because they explained that the Constitutional Tribunal does not exist. Initiation of criminal and disciplinary proceeding against judges. I can mention, for example, the first president of the Supreme Court, Małgorzata Manowska, and prosecutors. Unprecedented criminal repression against the political opposition in Poland, officially referred by the government as settling courses. So this is the official program. This is the point in the official program of the Civic Platform Party, that they are going to start criminal proceeding against opposition. Attempt to block the swearing in of the President of the Republic of Poland and generating a massive disinformation campaign alleging that the opposition in Poland had committed electoral fraud. Because the presidential election were lost by the governmental side, they decided to start talking about not taking oath from the president because it will be too much. They decided to accept this stay, but in fact we have a lot of actions against the constitutional, against the administrative legal system. In February 2025, the president of the tribunal, Mr. Bogdan Święczkowski, decided to conduct or to make the complaint and wanted to start investigation from the prosecutor office concerning the coup d'etat crime. So it was Article 2, 128 and 127, as Grzegorz Ocieczek explained the legal basis. And it was the official complaint, the official paper, which was made by the president of the tribunal, and in which Bogdan Święczkowski stated, the offense consists of the fact that from December 13, 2023 to the present day in Warsaw and other locations in Poland, these individuals, so the members of the cabinet, members of the government, have been operating as part of an organized criminal group at short intervals, acting on a premeditated plan with the aim of changing the constitutional system of the Republic of Poland and acting to bring about or halt the operation of the constitutional body of the Republic of Poland, the Constitutional Tribunal, and other constitutional bodies, including the National Council of the Judiciary and the Supreme Court, in concert with other individuals, undertook activities aimed at realizing this objective objectives through violence and unlawful threats by eliminating the ability of the Constitutional Tribunal and other constitutional bodies, including the National Council of Judiciary and the Supreme Court, to function, thereby undermining the constitutional of the Supreme Court's chamber for constitutional and administrative cases and Supreme Court judges, as well as the legal force of rulings issued by the Supreme Courts, including in particular those of this special chamber of the Supreme Court. It means that according to this official complaint, the new government started to change the constitutional system and to block and to neglect all bodies which would limited the power of the government. The investigation was started by the prosecutor Michał Ostrowski, who is still officially Deputy Attorney General. So the vice prosecutor general, the person who is one of the most important officially prosecutor in Poland. He started the investigation and start making all actions, collecting evidences, taking testimonies, and started immediately in 10th of February 2025. You have this decision here in my presentation. Mr. Adam Bodnar, so the Prosecutor General and Minister of Justice, decided to suspend Mr. Michał Ostrowski and starting the criminal and disciplinary proceeding. So the case that the investigation was took over and sent to the district prosecutor office in Warsaw, and the new prosecutor was appointed by this Minister of Justice, Adam Bodnar, to be vice prosecutor or district prosecutor of Warsaw, and the person, one of the most active members of the Lex Super Omnia Association, so the association of prosecutor which openly support the government. You have, for example, here in my presentation, this is the official statement from January 2024, which was published by the Lex Super Omnia Association, in which the association declared, welcomed with great satisfaction the appointment of Mr. Jacek Bilewicz as acting national prosecutor, and they said that we warmly welcome the actions of the Prosecutor General Adam Bodnar. It means that, of course, if the prosecutor who wanted to take evidences, make evidences, and make the whole investigation was suspended immediately, and the investigation was sent to the prosecutor who is, let's say, who has the warmly feelings to the new Prosecutor General and Minister of Justice. The investigation will be going, let's say, in the proper way. So, as to sum up, dear guests, dear visitors, dear ladies and gentlemen, this is the factual ground of the problem with the criminal responsibility. If we have, as lawyers, we know that the crime was committed, that we don't have any chances to start the criminal investigation against the main constitutional bodies or the person who are the member of the government. So thank you very much.